Hello, my name's John O'Brien, longtime member of the Real Estate Section Council and currently counsel to the Chief Executive Officer of Attorney's Title Guarantee Fund. I'm a real estate lawyer, and I want to talk to you today about things you ought to consider when you're representing both a buyer and a seller, primarily in a residential real estate context. What are your options? What sort of deeds are there? What do they mean? What should you look out for? What are the traps for the unwary? So you're representing a buyer. Is it a single person, a couple? Are they married? Are they not married? Are they seniors? All sorts of things that should be rumbling through your head as you start thinking about how you would like to advise them to take title to their property. If it's a single individual, well, your choices are pretty simple. It's going to go to that person in his own name or her own name. But that's not the most common situation at all. Let's take one that comes up very frequently. A young, unmarried couple that is planning on getting married in the next year or so, but is buying some residential real estate, which will be their marital home, but they're buying it now before they're married. This is an area fraught with difficulties. Very frequently, it'll turn out that one or the other parties is putting down the lion's share of the down payment money with some kind of a plan, probably not in writing, probably maybe not even fully verbalized, to split expenses at some level once they move in and prepare for their wedding. Well, you know, as a lawyer, you can see that there's all sorts of problems that could come up down the road. You know, what ifs, all those what ifs. What if the wedding doesn't take place? What if there's some sort of a falling out? What if their future in-laws don't get along with one another? All those sorts of issues. Of course, they don't want to discuss those. As far as they can see, the future is only rosy and happy. Well, here is the situation that I've seen many times in my practice, and boy, I hope you don't get to see it too. But of course, they buy the property, take title in only one of the names of the parties. Let's make it the wife. She has put down the lion's share of the earnest money. They're both living there, and they're both contributing to the mortgage payments. And now things don't work out, and the future husband wants his money back, wants his share of the equity. What's to happen? Well, a lot of this was going to revert back to the advice you gave them at the time of the closing when they're going into title. Again, in my example, only the woman is the title holder of record. Well, in a recent case called Tummelson, this is exactly what happened. Although, to make matters worse, the situation went on for several years. They were never married, just living together with the male contributing, depositing his paycheck every month into a joint account along with the wives and paying family expenses. This went on for several years when they decided to go in a different direction, and the property had appreciated in value, but again, it was just in the wife's name. And the appellate court said that the only claim that the husband had on this property was a return of the portion of the earnest money that he had put down. The rest of the money that he had paid over the years that went towards the mortgage payments and to increase in equity in the property was a gift, and he was not entitled to any of that property back. So a caution to you. If you have that situation, and trust me, if you are a real estate lawyer, you will have this situation, advise these people, even if it's just a paragraph or two, to come up with some kind of a written document explaining what should happen if this house is ever sold or if the relationship doesn't go as planned. That's situation number one. Situation number two, and by far the most common, is a husband and wife taking title to this property, both of them signing the mortgage, your everyday pedestrian real estate closing. Well, you really have two choices in this. They can take title as joint tenants, or they can take title as tenants by the entirety. What's the difference? Well, in each case, we're focusing on what happens if one of the owners of this property dies. Well, in both joint tenancy and tenancy by the entirety, of course, the surviving tenant will own the entire property, and it doesn't pass in any respect to anyone else. But there's a one significant difference, and that is in tenants by the entirety, if one of the spouses, and this applies, by the way, only to a married couple for their principal residence, if one of the spouses is sued or has some kind of a claim made against them, the judgment creditor cannot force the sale of the property. And that can be a significant benefit, particularly if you have, well, let's say one of the spouses is a professional, a doctor, a lawyer, somebody who could have a malpractice claim of some sort against them. This could be the difference between saving their house or losing their house. And in the industry, tenancy by the entirety has become the go-to method of choice for taking title to property. So, be cognizant of that. Another thing you should ask your clients if they are buying property, particularly if they are not the young couple that I've been envisioning in the first couple of examples, is are there estate planning concerns that should be looked at? Perhaps they have already, or maybe you have for them, have developed an estate plan. Perhaps they have a living trust or self-declaration of trust that's already been done, and that's where the property should be deeded to comply with their estate plan. So make sure you ask those questions if there's an existing estate plan, so that you can take that into consideration. Now, another thing you should consider, whether you represent the seller or the buyer in this residential real estate transaction, is types of deeds that can be used to convey title. And there are really three main types. The first is a general warranty deed, and this is the one you see over and over and over again, and the one that is most commonly used. But that term warranty, what does that mean? Well, in a general warranty deed, the seller of the property warrants to the buyer that there are no matters of record, not only just when he owned the property, but going back prior to him, there are no matters of record that could adversely affect the title to this property. If you're the buyer, obviously you want those kind of warranties for your client. Most commonly, there will be title insurance ordered as part of the transaction, which will show you what's of record. Another type of deed is a special warranty deed, which is a little different. In a special warranty deed, the seller of the property only warrants to the buyer that there's been nothing adverse affecting this property during the period of time when this seller owned it. Quite a different thing from the general warranty deed. Now, what's the practical difference? Well, consider this case that came from the 2nd Appellate District very recently. In this case, the seller of the property was a flipper. It was his business for some extra cash to buy property at foreclosure sales, fix it up a little bit, inflate the price, and sell it to somebody else. And that's exactly what happened in this transaction. He was a successful bidder at a foreclosure sale, did not pay for any title insurance at that time, and made the layman's assumption, of course not represented by an attorney at the foreclosure sale, that what a foreclosure means is that you get free and clear title to the property. Well, not so fast in this case. It turns out that there were 2 mortgages on the property, and the foreclosure sale only involved the second mortgage. So when the foreclosure was finished with, and he bought the property at the foreclosure sale, he took it subject to a pre-existing first mortgage. Well, sure enough, he fixed the property up, doubled the purchase price, and sold it to a third party. And you can guess the rest of the story. After a very short period of time, the third party realized that there was a pre-existing first mortgage on the property, and somebody had to pay it. The buyer sued the flipper, and as the result of this case, a general warranty deed was used, so the seller, the flipper, had made that warranty saying that there is nothing at all that affects the title to this property. If it had been a special warranty deed, it would have just said that during the time I owned it, there's been nothing new that's taken place. You can see there's a big difference there. So that's a trap for the unwary. So consider what kind of deed you expect to be used. If you're the buyer, you always, in my opinion, want that general warranty deed. So those are the 2 most common types of deeds that you'll see to property. Now, I know there's a lot more nuances to this. I know you might have a lot more questions. So I would encourage you that if you do have any questions, take a look at the ISBA website, look at the materials provided by the Real Estate Section Council, and as always, feel free to call one of the members of the Section Council. We're always happy to help.